what he said going back further to where we are now. So that's what we need to be very careful about.
Lords, following on actually from the noble lady Lawrence of Clarendon, I think that one of the difficulties that we've had in relation to any discussion like this is that the police are under an enormous amount of pressure because of the horrible things that happen, understatement of the year, to imagine that all speech can lead to violence. And if they do see that, then obviously they will police all speech and treat everybody's speech as potentially dangerous, damaging. And once that happens, we no longer live in a free, democratic society. It's quite straightforward. And one of the things that I think is very difficult is that the horror of Stephen's racist murder and the fact that the police didn't intervene, the fact that there was so much scandal around it, means that sometimes people feel very nervous or anxious about then saying that anything done in the name of fighting hate, they're worried about saying it in case they're somehow implicated in having prejudiced views. Because I'd like to enthusiastically welcome the government's Amendment 383, abolishing the statutory basis for non-crime hate incidents. Because actually, over the last few years, when some of us have raised problems with non-crime hate incidents and the policing non-crime hate incidents, as in attitudes and words, it has felt as though we were banging our heads against a brick wall. So it really does feel quite good to count this as something of a win, to be vindicated even, because to be honest, opposing non-crime hate incidents has meant facing some brickbats, both outside of here, as my capacity as the director of the Academy of Ideas, and, to be honest, especially in here, because there's been a less than subtle inference that opposition to non-crime hate incidents, or indeed a whole range of hate legislation, in fact, that revealed some lurking bigotry, or was proof that we were soft on hate. Yet here we are, and I think that's proof of something else that's important, that it's always worth raising issues here and battling on, because sometimes governments can change their minds. Sometimes the College of Policing can change their minds. You can make people look at things again. And I would also welcome the outbreak of common sense and reasonableness from the College of Policing, and the fact that there's been a genuine attempt at getting on top of what obviously was not intended from the original non-crime hate incidents. It's got completely out of hand. Despite that, and despite the fact that I'm really delighted that the notion of freedom of expression and free speech has now been taken seriously by the different bodies, I still have some worries, and I'd like some reassurance and clarification from the Noble Lord the Minister, I think. I am worried about the risk of non-crime hate incidents simply being rebranded. The government has suggested, and as we've heard, that some incidents currently recorded as NCHIs will continue to be recorded as antisocial behaviour incidents. And despite what the Noble Lord Young explained in terms of the higher threshold, actually, I want to just check with the Minister whether this behaviour that will be recorded that way will still be based on the subjective premise of a victim perceiving hostility or prejudice towards protected characteristics. And as so much antisocial behaviour regulation, as we discussed in an earlier part of the report, is prosecuted on a lower evidential standard, yet treated as a criminal offence, and can lead to criminal sanctions, could this lower threshold be used in these instances? I'm just worried about repeating the same problems. Can the Minister also rule out that any such antisocial behaviour hate incidents won't be added to the National Crime Database, being disclosed in enhanced DBS checks and being investigated in much the same way as NCHIs? I'm not actually sure about that. One of the reasons why I'm supportive of the amendment in the name of the Noble Lord Young of Acton 387B is it will make it harder to set up an alternative recording system that are NCHIs in all but name. I'm also worried, though, about ambiguity and confusion if we leave all this to guidance, as has been mentioned. As I understand it, police forces are not prohibited from continuing to record NCHIs under the government's amendment for quite a while, and I'm just not sure how this is going to happen. A statutory basis for NCHIs under Section 60 and 61 of the Police Crime Sentencing and Courts Act was simply a way for the Secretary of State to issue guidance. Can or won't it simply mean repealing the statutory basis alone, just return the police to the pre-2023 position where they continue with NCHIs under their own guidance? Maybe I've misunderstood that. Even if that's only happening temporarily until the government work out exactly what to do, I'm just concerned about this muddled period. Amendment 387, is it A or B? I can't remember. Rules out this concerning prospect and offers the police some clarity and guarantees the outcome that I think we all desire. Clarity or lack of it has always been a bugbear in relation to non-crime hate incidents. It's why I'm so anxious to hear how the government plans will be communicated, and I hope there will be clarity. On the one hand, we have experience of how a lack of clarity led to the growth of NCHIs without any intention for that to happen. Even the current DPP, Stephen Parkinson, admitted to the Times Crime and Justice Commission that until recently he, quote, had no idea what an NCHI was puzzled by it, and, quote, had to look up what on earth the term meant. And that was the current DPP, noting that even within the police service there has been some surprise at the level of non-crime hate incidents that were being investigated because they didn't know what they were. The last thing police forces need now are to be left in limbo in any way, while consultations or regulations or guidance is being sorted out. We know from an inspection into activism and impartiality in policing published by Her Majesty's Inspectorate in September 24 that there has been inconsistency in the way forces have responded to NCHI guidance. What happens if some of the more EDI enthusiastic forces carry on spending thousands of hours sifting through online posts, seeking out so-called hate and so on, investigating common everyday interactions as if they're crimes, which I know is not what the government or the College of Policing intend. Policing in limbo in law is never good, and any ambiguities can lead to the law being flouted. Just one comparison. As of October 2025, at the start of the academic year, only one university had complied with the Supreme Court judgment clarifying biological sex in relation to the Equality Act. The rest claim to be waiting for the EHRC code, waiting for guidance, rather than complying with their legal obligations. And I just don't want the same thing to happen. Now, I preferred the original Amendment 387, but I understand why it's been changed. But I preferred the idea of mandating all historic records of NCHIs deleted within 3 months of royal assent. The government amendment, however, does not directly address the matter of what will be done with existing records in relation to their ongoing impact on individuals' job prospects. As we've cited the noble Lord MacDonald of Rivergavin so much, I just wanted to quote him here, where he says, if you're going to attack someone's name in these instances, then you better be sure there's a good reason for doing that, because 5 years down the line, when they apply for a job, they might not get it. And that might be as a result of non-crime hate incident recorded against their name that was entirely baseless, entirely motivated by spite or misunderstanding or whatever. Now that these NCHIs could have been recorded against someone's name based on just those discredited, misplaced statutory guidance from the past, how can we make sure that they don't punish people now? I thought the noble Lord MacDonald's words when I was recently reminded of these when I met one of the teachers involved with 4 pupils in Wakefield who, if you remember, slightly damaged a Quran in 2023 and the police recorded an NCHI against them. Despite the school admitting there was no malicious intention, that one of the pupils was autistic, Inspector Thornton told concerned parents at the local mosque that the damage was being treated as a hate incident. And those young boys are now getting to an age when they will be applying for jobs. Does the noble Lord the Minister agree? It would be a travesty if their records of their NCHIs on the police database were used to stop them getting a foot on the work ladder. And I just want to make sure that we don't forget those victims who are a different type of victim.